In this lecture, we're going to be covering evidence, how it is important, how we obtain it, and how we handle it to ensure that it is admissible in a court of law. It doesn't matter if we have all this convincing, wonderful evidence if we have obtained it illegally or we do not have a clear chain of custody. Let's look at some of the types of evidence. First off, we have real evidence, and real, as it indicates, is physical, tangible objects. It's something that you can touch. For us in IT security, that is the hard drives, the USB drives, the servers. It is not the actual data. Then we have direct evidence, and direct evidence is something that is experienced with one or more of the 5 senses. They saw it happen, they heard it, they were there, they experienced it. Circumstantial evidence is something that on its own, it's not a fact, it's not something that we can use to conclusively prove they did it, but it can be used to support some of the other evidence or some of the other facts. Let's say there was a car accident. There may be no other witnesses other than you and the other driver. Maybe they're not able to identify you. But if on your bumper there's green paint and their car is green, that could be circumstantial. Or if you were at a gas station 5 minutes before, 2 blocks away, that could also be circumstantial. And if there are a couple of other things that could be circumstantial, it could be this explanation, but they could also be explained in another way. If we have enough circumstantial evidence, that can become cooperating evidence. Again, on its own, it doesn't prove anything, but if you have 2 or 5 or 10 things that point towards a certain conclusion, then that conclusion is more likely. Which then brings us to hearsay. And hearsay is not first-hand knowledge, and normally it is inadmissible in a court of law. But I say normally here, because computer-generated records, and with that logs, are still hearsay, but they are also admissible in a court of law, assuming they were made near or at the time of the attack, that they have a clear chain of custody, and that it is unaltered. And we would ensure that it is unaltered by making a hash of the logs as close to the actual attack. And if you remember with hashes, if you change just 1 comma in a 100-page book, the hash will be entirely different. So in a court of law, if we can prove this was done an hour after the attack, this is the hash from that file from that date. This is the hash from the file that we have now, because we don't ever do forensics on the original. We make a copy of the original, we hash both the original and the copy, make sure the hashes match. If they do, it is an identical copy. Then we do our forensics on that copy. So for our evidence, we want to follow the best evidence rule. Best makes sense. Obviously, the better evidence we have, the higher chance we have of a conviction. So it should be accurate, complete, relevant, authentic, and convincing. And this is all the stuff that was real or direct evidence. Then we have secondary evidence. That is our hearsay from earlier. The logs from the system that was attacked, any documents or any traces they may have left behind, secondary evidence. Because with many computer crimes, there is no real evidence. There's nothing you can touch. There might not even be direct evidence. Someone hasn't experienced this. They haven't felt it or seen it or heard it. So no direct evidence. What we're left with is circumstantial, corroborative, and hearsay. And since that is all that we have, then it is very critical for us to preserve the crime scene and the integrity of the evidence. When I mentioned earlier that we make a copy, we hash both the original and the copy, and they should match. We work on the copy. When we're done working on it, we do another hash. It should still match. If it does not, something was changed. If we can't preserve the integrity of the evidence, then we probably can't use it in a court of law. And the same with chain of custody. We have a chain of custody log. Who handled it? When did they handle it? What did they do with it? And where did they do it? And here again, it is only staff that is trained to do exactly this that are allowed to handle the evidence. Let's say there's an attack. They left something behind that we can possibly use as evidence. Well, then we remove the hard drive from the system. We put it in a write blocker, which is just a piece of hardware or software that only allows reading from the drive nothing can be written to the drive, which preserves integrity. We hash the drive, we make a copy, we hash the copy. At this point, the original drive is placed in an evidence bag and it is sealed in there. We also have that in a write blocker. We then work on that copy. When we're done with our forensics analysis, then we do another hash. All three hashes should match. And while the certification is international and is recognized across the world, just remember it was started in the United States by Americans. So it is going to lean more towards US laws and US regulations. The laws we're going to cover in this section and the next ones will have counterparts in most of the world. For the exam, know the ones that we cover here and the ones that the books cover. For your job, you need to know all the laws and the regulations that are relevant for your country and the organization you work for. And it is important to understand the laws, but it is maybe even more important to understand the concepts and the reasoning behind them. First off, let's look at reasonable searches. The Fourth Amendment of the United States Constitution protects all citizens against unreasonable searches and seizures by the government. That means that in all cases, a court will determine if that seizure or search was reasonable, if the evidence was obtained legally. If they don't have a search warrant, well, then they can't search your house, with a few exceptions. And the exception is in exigent circumstances, which means if there is an immediate threat to human life or destruction of evidence, then law enforcement or those acting under the color of law can intervene. That can be off-duty police officers or judges or prosecutors. It is someone who is employed by the government. And here again, it is up to a court to decide if it is still obtained legally and if there was a threat to human life or the destruction of evidence. And now for another little warning. When we monitor what our employees do, we need to be very clear that they understand that whatever they do on company property using company equipment is being monitored and can be used in whatever way that we deem necessary. And this is based on our policies that are of course made within the rules and regulations and laws that we need to adhere to for privacy in the area we work in. While some people might think that it's a great idea to monitor everything because then you have proof if you ever need it, it is likely that it is probably illegal, possibly something we can be sued for or fined for, and if we ever wanted to use that evidence, we couldn't because it was not legally obtained. And this is a trend we're seeing across the world. Privacy laws and regulations are getting much stronger, and the European Union is definitely on the forefront of that. The US, for now, not so much. And let's finish out this lecture by looking at two key legal concepts, entrapment and enticement. First off, we have entrapment. It is both illegal and it is unethical. And entrapment is us convincing someone to commit a crime they were not planning to do already. It is you saying, hey, you should hack this server because you can sell the information for $100,000. If they had no intention of hacking that server to begin with, that is entrapment. Whereas the other side of that coin, enticement, is both legal and ethical. They have already planned to commit the crime. You are just making it slightly more attractive. If they had already planned to hack that server and you then open some of the ports on the server or enable services that normally wouldn't be enabled, that is enticement. One of the ways we can use enticement could be honey nets or honey pots. We will cover those more later. And like with most other things that are somewhat opposites, there is some gray area in the middle. For those gray areas, it is ultimately up to a jury in the end to decide if it was enticement or entrapment. And just a quick warning, whenever we deploy honey nets or honey pots, first off, have a sign-off from senior management, probably human resources, and definitely our legal department. Because honey pots and honey nets present very real, both legal and practical risks.